What's the process for carrying out a mediation? Generally, it's going to depend on the mediator and the agreement between the parties or the court order or statute controlling the mediation process. But generally, the parties meet or get together in the presence of the mediator. The mediator hears the argument from either party. That is, the mediator will allow each party to spend a few minutes presenting their side of the case or situation and any documents they may have, etc. Now, the mediator has already reviewed any documents or other evidence that the parties have provided him or her at that point in time. So they're already familiar with the situation, but it may help the mediator to hear one party explaining their side further. Now, after each party presents their side of the argument, the mediator would generally separate the parties in some way, shape, or form. Normally, they're kept together in a single location. They're simply put into different rooms. Now, the reason for this is because the mediator needs to generally play devil's advocate of sorts, that he or she runs back and forth between the parties, trying to bring the parties closer together on how they can resolve the issue or dispute. And it helps to be in person to be able to help negotiate the issue in person again. These separate sessions can last days, can last hours, depending on the depth of the dispute and the party's willingness to continue on with the process. Now, if the mediator is successful in bringing the parties together to a point of agreement that they can settle the dispute, what they've done is negotiated a settlement. Depending on the role of the mediator will either seek to record some of these agreements or terms or charge one party with writing out the terms of the negotiated settlement and to present to the other party. Now, if this can be done relatively quickly, the mediator can oversee the signing of this negotiated settlement and then the dispute is settled or over. Or in some cases, the parties will simply leave it there, that they've reached a settlement based on these terms. The mediator will record those terms and, yes, either draw up a negotiated settlement document or charge either party with doing that, and then the parties can execute that. Generally, a mediator is paid by both parties. To avoid bias, you don't let one party versus the other pay. Now, if the negotiated settlement was mandatory, oftentimes the court will enter in a judgment on that mandatory mediation. So the results of the negotiated settlement will have the force of a court order behind it. In voluntary mediation, this is more rare, but if the mediation took place or happened in conjunction with litigation, oftentimes the parties will seek to enter that negotiated settlement into court to get a judgment on it as well.